Hello, I'm Professor Rich, and this is TYT History. A little while ago, I made a video on the history of judicial activism, and got a good response, a lot of views. One of the comments was, I was expecting you to talk about John Marshall, and that was from Jay Yagos, and I told him I would do a whole video on John Marshall because I thought he was that important, and this is that video. So I want to talk today about John Marshall, the fourth Chief Justice of the United States Supreme Court. Now, to understand John Marshall, we have to understand where he came from, how he got the job. And so we need to talk about the election of 1800. Well, the election of 1800 is one of the most important elections in American history. Thomas Jefferson beat John Adams. And the key to this election, why it's so important, is it was the first time in American history that we changed parties in leadership. The Federalists were out. They had been in control from 1789 to 1801. And now the Democratic Republicans are going to take control in the form of Thomas Jefferson. And they're also going to take over the House and the Senate. Now, many people, not only in America but around the whole world, were very curious to see what happened. Was there really going to be a peaceful transition of power? Were the Federalists going to willingly walk away from power? And were the Democratic Republicans going to come in and not go after their political enemies? And it's one of Jefferson's great gifts to this nation, and he gave us so many, that he does not try to seek revenge on the Federalists, and he doesn't even undo their programs. And Jefferson argues that the people elected the Federalists, therefore we should honor those programs and the laws that they passed. Unfortunately, John Adams wasn't quite so magnanimous, and in a bit of a panic after losing the election, he is going to attempt to pack the federal courts with friendly judges, with Federalist judges who are young and highly ideological. Now, this is really why I'm making this video, because I think we tend to look back on history, and particularly founding fathers, big names like Jefferson, Adams, and John Marshall, and think that these guys were these pure spirits who were trying to create this grand experiment and bequeath us this incredible legacy of democracy. That's not true at all. They were just as partisan and petty and self-interested as any politician today. And that's what I want you to understand from this video. So John Adams appoints all these Federalist judges, and his goal is to try to stop the Democratic Republicans from implementing their programs, and he figures he's going to use the courts to do this. Now, one of the Federalist judges he's going to appoint is John Marshall. John Marshall is going to be made the Chief Justice of the Supreme Court. Now, there already was a Federalist Chief Justice of the Supreme Court serving, but he was sickly. He wasn't doing well. And Marshall was a younger man and in better health, so they decided to just boot that guy because they didn't want him to die shortly after Jefferson took office, and then Jefferson would get to replace him, and just trade him in for a newer model, so to speak. Marshall actually wasn't the guy they wanted, but he was there. And it was very important that they get him installed in the position before Adams left office, and so they settled on him. Adams, by the way, would call John Marshall his greatest gift to America. I'll let you decide about that here when we're done. Now, these judges, by the way, who were put in the last minute were called the Midnight Judges, and it was the Secretary of State's job to deliver the appointments. Now, who was John Adams' Secretary of State? It was John Marshall. And John Marshall didn't get all the appointments delivered. It was a big job, and it just didn't get done. So when Thomas Jefferson comes into office, there are still some undelivered appointments literally sitting on his desk. Well, Adams and Marshall had assumed that Jefferson would just deliver them, and Jefferson decides, why should I deliver them? The former president can't tell the current president what to do. That doesn't make any sense. I'm under no obligation to deliver these. And so he gives them to James Madison eventually. It's a little more complicated than that. And one of these justices, John Marbury, is going to sue James Madison. He's actually going to ask the Supreme Court for a writ of mandamus, ordering Madison to deliver the appointment. Well, John Marshall probably should recuse himself at this point. I mean, think about this. Not only is he one of the Midnight Judges, which is the center of the case, but he's the Secretary of State who failed to deliver the appointment. This seems to be too much personal involvement for a judge to sit on a case, but John Marshall isn't interested in that. What he is interested in is claiming a lot more power for himself so he can serve as kind of a bulwark against Democratic-Republican policies. And so what he does is he actually rules in favor of Jefferson. Now, Jefferson actually disagrees with it. Jefferson argues, which is interesting because Jefferson won, so to speak. But what Jefferson points out is that John Marshall has just claimed the right to undo any action of Congress or the executive branch. And Jefferson argues that this could turn the Supreme Court into an oligarchy, who would become more powerful than both of the other two branches. In fact, many constitutional scholars still argue about how powerful the Supreme Court was ever supposed to be in the first place. Many conclude that it was supposed to be a fairly minor branch, simply dealing in technical issues that came up. In fact, before Marshall takes over the Supreme Court in 1801, we have a Supreme Court justice who walks away from the job to go be a state judge in South Carolina. We have a Chief Justice, John Jay, who leaves the job to go be the governor of New York. So it won't really be until John Marshall gets there and then uses Marbury versus Madison to dramatically increase the power of the court that it becomes a major job. That's judicial activism. Now, the big political issue of the day, the key issue in this country from our founding until the end of the Civil War, is the balance of power between the federal government and the state governments. The Federalists, as their name implies, wanted a strong federal government. The Democratic Republicans tended to trust more in state power. Well, Marshall will use his unelected position, this is the Supreme Court, to push the country more and more towards a concentration of federal power. Now, is this what the country wanted? Well, it's hard to argue that it is, because the Democratic Republicans will win every single election from 1800 to 1836. Yet here John Marshall is taking the country in the exact opposite direction by using the power of the court. In a long series of important decisions, he's going to increase the power of the federal government to the detriment of the states. In Fletcher v. Peck in 1810, he will use the federal courts to overturn a state law. In Cones v. Virginia in 1821, he'll take a Virginia state criminal case on appeal to the Supreme Court and overturn the state court's ruling. In McCulloch v. Maryland, he will strike down Maryland's attempt to tax the Bank of the United States in their state. In Gibbons v. Ogden, he will strike down a state charter to operate a ferry across the Hudson River between New York and New Jersey in favor of a federal charter. All these cases are really the basis for federal power over state power that, of course, we're all familiar with today. And if there's anything he liked more than federal power, it was corporate contracts. The first key corporate contract case is Dartmouth v. Woodward. And this is New Hampshire's actually trying to force Dartmouth to become a public university. And Marshall will rule that this can't be done because the corporation charter that founded Dartmouth is inviolable. It cannot be violated by either the state or the federal government. And this really establishes the dominance of corporate contracts in American law and really is the cornerstone to what will eventually become decisions like Santa Rosa and, of course, Citizens United. Now, I'm not necessarily against any of these rulings individually, but I do want you to understand that they are clearly politically motivated judicial activism. The Democratic Republicans had their own problems, but they did have a distinctly different vision, and John Marshall is going to use the Supreme Court to get his way. He'll be the Chief Justice for 34 years, the longest-serving Chief Justice in history. He will be in the dissent one time in 34 years on the court. This is a man who had an iron rule over the court. And I want to finish by talking about one final case. And this is a case called Charles River Bridge versus Warren River Bridge. And this involves a toll bridge over the Charles River in Boston. And it was making a lot of money. And the people of Boston were having to pay a fee, a toll, every time they walked across the bridge. A competing company, a government contract, was going to build another toll bridge that would essentially, after a period of time, be free. Well, this is what the people of Boston wanted, but the first bridge, of course, they didn't want to lose their monopoly. They wanted to keep making all this money. This case actually goes before the Marshall Court, but due to people being absent from the court and sick and being unable to get together, the Marshall Court never issues a ruling on it. It is clear that Marshall wanted to rule in favor of the first bridge, of the toll bridge, and against the free public bridge. Now, the Taney Court will eventually hear the case in 1837, and I'm no fan of Roger Taney. He's the guy who wrote the Dred Scott decision. I kind of hate the guy. But he did say something here that I got to say I like. In the Charles River Bridge, he's going to say, the existence of such a power, and he means the power of the government to protect a monopoly against a publicly operated good. The existence of such a power in a representative body has no foundation in reason or in public convenience and is inconsistent with the principles upon which all of our political institutions are founded. So what he says there is this government was founded to help the people, not the corporation, make money. So that's something to think about. That's a different direction maybe our courts could have gone from the very beginning instead of going through 34 years of John Marshall. Anyway, I hope you learned something. Thanks for listening. Tune in next time.